it's not very often that you can, or anyone can, accurately describe a piece of legislation as exciting. But I think that I and other people can perhaps be forgiven for using that term in respect of this piece of law. And one of the reasons for that is that I came to Doha 5 years ago this very month. And why is that relevant? That is relevant because one of the very first meetings I attended in my capacity as then acting registrar, I was told that the new Qatar Arbitration Law was imminent and that practitioners would be able to use it very soon. Now, it turned out that what was meant by imminent was 5 years later, but now that it's arrived, I think that we must all welcome it with the enthusiasm that we would have welcomed it 5, 4, 3, 2, 1 year ago, and I hope that during that time people's desire for this piece of legislation has continued. The focus of my presentation is going to be on the role that the court plays in and under the new arbitration law. One of the most interesting pieces of this legislation is that it gives parties the opportunity to select what is described as the competent court when it comes to matters relating to the supervision of the arbitration. Now, you all have a copy of the English translation, and indeed it also includes the original Arabic text in front of you. And if you look at the definition section, you will see that that is how the competent court is defined. The underlined part of that is, of course, in reference to the court here at the QICDRC. And the second important point to take away from that is that it is pursuant to the agreement of the parties. So it is important that parties who wish to elect to use the QFC court as the competent court agree to do so. The other important definition is the competent judge, who is distinct from the court. And you will see that once again parties are given the ability to elect who the supervising judge will be when it comes to matters relating to enforcement. How do you ensure then that you choose, if you wish to choose, the QFC court and the enforcement judge at the QFC court to be in control of matters relating to the arbitration? There is a loose leaf card inside the little booklets that you have, which contains what we suggest is the correct formation of words to use in order to ensure that this court of the QICDRC has jurisdiction over matters relating to the arbitration. And I've included an extract there which relates to how you may go about ensuring that the QFC court is the appropriate court. Here are some examples I suggest that would not be sufficiently precise in order to ensure that the QFC court is the right court. Now, I say that because all of those definitions which are currently on the slide could be interpreted in such a way so as to include this court. The problem, of course, is that they could also, and I would suggest more readily, be interpreted so as to include the domestic Qatari courts. Now, it's clear that it must be, of course, up to the parties to determine which of the two courts they want to supervise the arbitration. And what we say is, if you use the wording suggested in the model clause that we've provided, then it is clear and unambiguous that you are selecting the QFC court. Because what you don't want to happen, before a matter can be properly seized by one of the courts, for the respondent party to argue that the court that you filed your application before does not have jurisdiction to determine the issue concerned. So again, that is what we say is the correct wording to use. This is all very well for arbitration agreements which have not yet been drawn up, but what to do in cases where you already have an arbitration agreement in place, or indeed you already have an arbitration ongoing. The reason that's important is because if you look at Article 3 of the preamble, the law makes it very clear that the provisions of it apply not only to arbitrations which have not yet commenced, but also to arbitrations which are currently ongoing. Now, there have been a number of views expressed at various seminars that have been dealing with the issue of the new law, about how one might go about referring the matter, for example, to this court, in the context of a pre-existing arbitration. Popular opinion seems to be, and it seems to me to be sensible, that unless the parties agree at the time or prior to the need for arbitration, or in particular the need for the matter being referred to the court arising, then it would be difficult for this court to be appropriately seized of any application. I think in practice what is likely to happen, of course, is that in the context of a pre-existing arbitration, the claimant is going to be the one to determine where they file the appropriate application. And then the respondent will have to raise, should it so wish, any jurisdictional challenges following the claimant lodging any application. And then the court, whether it be this court or the domestic court, will have to determine whether indeed it does have jurisdiction to resolve the matter. But I don't think, on any view, the best way to ensure that you choose the right court is to have a clear clause from the beginning. And if you are in a pre-existing arbitration, hopefully you and your counterparty will, if you don't agree on anything else, you will at least be able to agree which court should resolve any difficulties. Article 6 of the law summarises the relevant articles contained within the law which may involve exercise of functions by the competent court. It's not an exclusive list actually, but it highlights the main functions. The appointment of arbitrators is dealt with by Article 11 of the law, and the court can get involved in relation to the appointment of arbitrators in circumstances where the parties fail to agree or fail to appoint an arbitrator in accordance with agreed procedures. Similarly, if they have agreed procedures which they don't follow, that is also susceptible to challenge before the competent court. And a decision of the competent court is not susceptible to appeal. That's worth bearing in mind, because if you choose the QFC court as the competent court, you will probably be familiar that it has two tiers, a first instance division and an appellate division. And what the law is saying here is that the first instance division will be seized of all matters relating to arbitration, and that once the first instance court has made a decision, that decision is not susceptible to any further challenge. Hopefully, that will be welcomed by practitioners, because the aim is clearly to ensure that the arbitration is not thwarted by constant challenges before multiple divisions of the court. If the court does need to get involved with the appointment of arbitrators, then Article 11, 8 through 10 deals with the considerations and requirements that both the court and the parties have to bear in mind. 11.8 requires the court to have due consideration to the nature and circumstances of the dispute, the qualifications of any proposed arbitrator, their independence, and then there is also reference to their nationality. Selecting the arbitrator is perhaps what is of most interest to those who are arbitration practitioners, and perhaps more likely those who are arbitrators themselves. Are you going to be eligible for appointment as an arbitrator? Well, much could be said about other provisions contained within the law, but I would suggest that Article 11.10 deals with the matter quite clearly, because if you look at Article 11.10, you will see that the competent court can choose an arbitrator from the registry held by the Ministry of Justice, or from the lists of other arbitration centres, or from any other list that the court deems appropriate. So, providing you're on a list of some description, then it appears that that is the main requirement for ensuring that you are, at least in principle, capable of being appointed as an arbitrator. And that's Article 11.10 there in full. Of course, if you can deal with the appointment of arbitrators, it follows that you must also be able to deal with their removal. And that is dealt with by Article 13 of the new law, which in summary form requires that any request to remove an arbitrator should in the first instance be made to the arbitral tribunal, and only if the parties or the individual arbitrator concerned refuses to recuse him or herself, may the matter be referred to the competent court. There's an amusing, well, it's amusing if you're not an arbitrator, provision that talks about matters relating to fees and expenses. And the reason I say it's amusing is because the clause says that, and this is Article 13.2, that once the court has made a decision in relation to removal, it can determine the fees and expenses of the said arbitrator. There's nothing unusual about that. But it then says, or to recover any fees or expenses paid to him. So that is, on the face of it, suggesting that if you have been appointed and you've incurred fees and expenses and are subsequently removed, then there could be a requirement from the court that you pay back monies which have already been paid to you. Something to perhaps bear in mind. And there is an important provision stating quite clearly that multiple requests for removal will not be entertained. That is Article 13.3. So you can't keep making an application to the competent court requesting a removal of an arbitrator unless, of course, new reasons are proffered. Article 14 deals with a very specific circumstance in which the competent court may be asked to remove an arbitrator, and that is in cases of what is termed as unjustifiable delay. And you will see from Article 14 that in cases where the arbitrator is unable to perform or commence his function or ceases to perform it, and that leads to an unjustifiable delay, then the competent court may order his removal. But that is only on application of one or both of the parties. Jurisdictional challenges, they are dealt with by Article 16, and much like the preceding articles, you must first of all raise such challenges before the arbitral tribunal, and only if the arbitral tribunal dismisses the plea as to jurisdiction would you be able to challenge that before the competent court, and you have 30 days in which to do that. And similar to other rules, challenges to jurisdiction do not prevent the arbitral tribunal from continuing to hear the dispute and or from issuing the award. So anyone who thinks it's a good time-wasting opportunity to submit a frivolous jurisdictional challenge before the court because it will stop the arbitral tribunal from hearing the matter would be mistaken. Another power the competent court has is pursuant to Article 27, and that is to assist the tribunal with matters relating to the taking of evidence. In this instance, the tribunal or the parties, with the tribunal's consent, may seek assistance from the court as regards matters relating to the taking of evidence. In other words, if you need orders relating to witness summons, the production of documents, and so on and so forth, the arbitral tribunal can seek the assistance of the court to help it with that. The obvious reason being that the court has much more powers in that regard than the tribunal does. And there's Article 27.2 setting out the basis upon which the court can do that. I would make two observations in relation to Article 27.2. One is that it refers to the competent court exercising its functions in accordance with the rules it applies, it being the court, concerning obtaining evidence. And then it goes on to specifically say that the court has powers under Articles 278 and 279 of the Civil and Commercial Procedure Law. Insofar as the competent court being the QFC court is concerned, then the primary source of its powers, which would be of application to Article 27, are contained within Articles 10, 26, 27 and 34 of its own procedural rules. And those provisions cover matters relating to disclosure of documents and evidence generally, as well as to witness requirements, including summons. And then Article 34 deals with enforcement and matters relating to contempt. And the court, under its own rules, has very wide powers to deal with parties who fail to comply with directions and orders that it makes. So that would be the principal basis of the QFC court exercising its functions in accordance with this, this article. But it has as a fallback position Articles 278 and 279 of the Civil and Commercial Procedures Law. But if you look at those, and I must confess that I had never had cause to look at them until this law came out, Articles 278 and 279 are very specific. Article 278 just refers to the power to summon a witness to appear, and Article 279 prescribes for a financial penalty in the sum of 200 reals if you fail to comply. And then there is a rather oblique reference to issuing an order through the police for a witness to appear. The point I might make is that the court's powers under its own regulations and procedural rules are far wider than those contained within Articles 278 and 279. Indeed, one part of Article 34 of the court's own regulations, actually after it prescribes the list of things the court can do, also refers to it being able to issue any order that it is in the interest of justice to do. So the court has very wide-ranging powers under Article 34 of its own regulations. Correcting awards, it's not unusual, of course, to provide the arbitral tribunal with the ability to correct awards in the terms set out in Article 32A and B, which are up on the slide at the moment. What is perhaps slightly more interesting is what happens if the tribunal fails to do that. And Article 32.6 says that if it is proven impossible for the tribunal which issued the award to convene in order to hear the request for correction or interpretation, then you can refer the matter to the competent court unless the parties agree otherwise. Now what that means is that the court, which of course played no part in deciding the award, could be requested to deal with matters relating to correction or interpretation if it was proven impossible for the arbitral tribunal to do so. It is not ideal, of course, for the court to be put in the position where it should do that. The arbitral tribunal should always be used, where possible, to perform that function. And the reason I specifically raise that point is because if you look at the time limit that the arbitral panel has to make these corrections, it is specified as 7 days under Article 32.1. Now 7 days is not very long, which is why there is the ability for the parties to agree an alternative period. And my suggestion would be, if you are arbitrating pursuant to this law, at a pretty early stage you agree what may be considered a more realistic time limit for arbitrators to make corrections pursuant to Article 32. Because if you don't do that, and the 7 day limit applies and it passes, then your only recourse will be to the court under Article 32.6. Unsurprisingly, there is the power to appeal an arbitral award to the competent court in accordance with Article 33(1) of the law, and there is nothing particularly unusual about the grounds, which I'm not going to read out, but you can see that the grounds are contained at 33(2), from which one can make a challenge to an award before the court. The only two matters I draw your attention to is that, again, the time limit is 1 month unless you agree to extend. I think UNCITRAL is 3 months, so this is a much shorter period. So it means that once the award is issued, particularly if it's a lengthy award, you're going to have to address your minds to it at a fairly early stage in order to identify whether there are any grounds for challenge. And if there are, make sure you lodge your appeal within that deadline. And Article 33(5) permits the court to stay any appeal and remit a matter to the arbitral tribunal for correction. That's fairly interesting. I interpret that as meaning that if it is some sort of technical or procedural error that the court has identified, rather than allow an appeal, it could remit the matter back for the arbitral tribunal to address, and then sort out the issue. But it'll be interesting to see how that particular provision works in practice. Challenging enforcement, again, that's dealt with by Article 35(3), and the grounds upon which you can challenge the enforcement of award are not unusual, but are clearly specified in the law. I wanted to end by looking at some of the powers that the competent judge has, because, as I said at the beginning, that the law does make a distinction between the competent court and the competent judge, and some powers it vests in the former, some it vests in the latter. Interim measures, which are provided by Articles 9 and 13 of the law, are examples of powers which are vested with the competent judge, who is the enforcement judge, as opposed to the court. And you will see from looking at 9 and 13 that the competent judge has the power to issue and enforce interim measures, and will do so unless they're clearly contrary to the law or public policy. Here are some requirements that must be fulfilled in order to seek the competent judge's order of enforcement pursuant to Article 34(2). They're not, I would suggest, particularly contentious. You have to submit your request in writing with a copy of the arbitration agreement, an original award or certified copy, and a certified Arabic translation. The only thing that is potentially interesting is that that article ends with the words, unless the parties agreed on alternative methods to enforce the arbitral award. So it would seem that if the parties agree, they can circumvent the requirements of Article 34(2), providing they agree as to some other alternative proposal. Time limit, you cannot apply to enforce an award until the lapse of time is set for the submittal of an application for setting aside the award. So in other words, until that period has elapsed for challenging the award, you cannot submit an application for enforcement. I'm not going to read out the grounds for refusing enforcement. You can have a look at those yourself. And just before I close, I wanted to make an observation about the court's power to enforce generally, and that is, until last year, notwithstanding the length of time this court had been in operation, there had never been any request to enforce either an award or a judgment of the court. And so, quite understandably, there was speculation amongst practitioners as to how the court may grapple with the issue of enforcement, particularly, of course, given very well-known issues that people have observed in our neighbouring jurisdiction of Dubai and the DIFC. So when the first application for enforcement was filed last year, and that was in relation to a QFC court judgment, a lot of people were very interested to see how it would be dealt with. Now, as you may have noticed from the judgment itself and from a number of publications which followed, the enforcement judge at the court took the view that because the QFC court is enshrined in the law as a Qatari court and forms part of the Qatari legal system, then the powers of the enforcement judge to enforce are not limited to assets contained within the Qatar Financial Centre. He can enforce the judgment throughout the state of Qatar, and that is precisely what he did. And the reason that is important is because for those of you who have experience in other, shall we say, similar jurisdictions, there is always the difficulty at enforcement stage of how you go about accommodating the requirements under the various financial centre laws, and then also the applicable enforcement regime in the broader state. It is encouraging that that is not a problem that practitioners here will face, because the QFC court has taken the view that in accordance with the law, it's not restricted in the same way as other courts might be. And there's absolutely no reason why, in principle, that would apply any differently to the enforcement of an award as it would a court judgment. So that is my presentation, and I shall hand over to